While the U.S. Supreme Court still is yet to make a ruling on whether or not they're going to take the state of Illinois gun ban challenges, they did say they're not taking Maryland's challenge before a final judgment. But it's possible you could still see something from the U.S. Supreme Court on the collection of cases from Illinois, while you've also got the Illinois Supreme Court taking up a case concerning firearm laws. It is Bishop on Air, back at it. Thanks for hanging out. Appreciate you guys being here and being part of the program where we take a look at some things going on across the country, but also right here in Illinois. And obviously, yesterday was a big day with the U.S. Supreme Court issuing their orders list. And just for background, for those who need sometimes the reminder of how this stuff works, Southern District of Illinois Federal Court had a bunch of gun ban challenges based off the law that was passed and enacted back in January 2023. You had cases in the Southern District, you had cases in the Northern District. Federal Court, all right, they went different ways. So you had a split district of sorts, and then goes up to the Seventh Circuit Court of Appeals, where they had that, taken under consideration. Seventh Circuit Court of Appeals, on a preliminary basis, said the state had a likelihood of succeeding on the merits. Well, the Southern District courts, they decided, you know what, we're going to go ahead and we're going to start moving forward with this on the merits. So we're actually looking at a possible trial on this in the Southern District on the merits sometime in July. So interesting to see that. But while that was playing out in the Southern District, you had some plaintiffs ask the U.S. Supreme Court to intervene. And that was what was up for conference last week. We get the order list. It does not have Illinois' cases on it, which means it's relisted. And if we look at some of the individuals who are watching this closely, Chuck Michel, for instance, he says that SCOTUS denied a cert request in the Bianchi semi-automatic case today. That was the Maryland case, and relisted the Illinois cases for this week. So we will see what they decide on those next Monday. Fingers crossed. Hannah Hill from the National Foundation for Gun Rights says we survived our first court conference. This means it's not an immediate no from SCOTUS on our Illinois assault weapon ban cert appeal. This is fabulous news and exactly what I was hoping for. Our next SCOTUS conference date, May 23rd, we'll be watching next Tuesday's order list. And then you could see, again, some of the kind of analysis here. And even the Firearms Policy Coalition saying that their lawsuit challenging Illinois' assault weapons and magazine ban has been distributed to the Supreme Court conference on Thursday. The soonest we could have yet another update in the case is May 28th. So May 28th is yet another day that we're going to have to watch for. But you've got the Southern District of Illinois Federal Court that's moving forward with the merits of the gun ban challenge in that district court. But it's not the only gun litigation that's going on. Today, in the Illinois Supreme Court, 9 o'clock, they have a case here I was not familiar with until I was reviewing the docket for the Illinois Supreme Court. And what we have here is the case Davis and Davis versus Yenchko, Jeffrey Yenchko. He's the chief of Firearm Services Bureau at the Illinois State Police. What is this case about? Well, with the Supreme Court cases in the Illinois Supreme Court, when you get briefings filed, you get these things called, kind of an overview and the questions that are being asked and the issues that are going to be tackled. So we'll actually cycle through all of this. And the nature of the case, the Illinois Supreme Court docket in this case says plaintiffs are charged with recklessly endangering the safety of others by repeatedly shooting a semi-automatic rifle into the air, a felony case. A few days later, the state police revoked plaintiff's FOID card based on section of the law, the Illinois Firearm Owners Identification Card Act, which authorizes such a revocation when a person is prohibited from acquiring or possessing firearms under federal law. It goes on to say that as relevant here, the law imposes firearm restrictions on individuals charged with a felony by prohibiting them from acquiring firearms. Plaintiffs later pleaded guilty to a misdemeanor and their FOID cards were restored. I think that's interesting, right? And these individuals were charged with a felony, but they pleaded down to a misdemeanor. You're innocent until proven guilty in a court of law. And if you plead down to a lesser crime, you plead down to a lesser crime and it doesn't really go to a court. So that's essentially what happened in this case. They were charged with felonies, but they pleaded down to misdemeanors, and their FOID cards were restored. Some months later, plaintiffs filed this action arguing that the operations section of the FOID cards for those charged with felonies and thus subject to the restrictions violated the Second Amendment of the United States Constitution, and seeking a declaration and injunctive relief. Defendant, the chief of the state's police firearms bureau, argued that plaintiffs lacked standing, or alternatively that the case was moot because plaintiffs' FOID cards had been restored. Defendant also argued that even if the case was just justiciable, it was constitutional. Or the law was constitutional. The circuit court applied the public interest exception and the mootness doctrine, both to overcome mootness, and concluded that the exception was also gave plaintiff standing. And then it held that section of the law violated the Second Amendment with respect to anyone charged with but not yet convicted of a felony. The court entered a permanent injunction prohibiting defendant from revoking the FOID card of any person based on a felony charge. Defendant appealed directly to this court, which granted a stay in the circuit court's injunction pending appeal. I was familiar with this case, but I didn't realize it was in front of the Illinois Supreme Court, or maybe I did. I just get so inundated with so many cases. It's pretty wild, but that's going to be heard with oral arguments today in the Illinois Supreme Court. All right, 9 o'clock. It'll be interesting to see what happens here. 9 o'clock, if you go to the Illinois Supreme Court's website and go to the docket, you should be able to watch that at, again, 9 o'clock today. So, again, while you've got all of these other cases popping off with the U.S. Supreme Court looking at Illinois' gun ban and possibly going to another conference where we could get more information later on this month as to whether they're going to take those cases on a preliminary basis, by the way. While the Southern District of Illinois Federal Court continues to move forward on the merits, you've got the Illinois Supreme Court taking up the issue of the constitutionality of FOID card revocation among charges, not if somebody's convicted, but merely just charged. So we'll be watching that. We'll bring you some of the latest tomorrow on that case. It's right here with Bishop on Air. Thanks for hanging out. Like, subscribe, hit that notification bell. And I've got some of you guys out there saying that you have to keep subscribing, which is interesting. But hey, just keep me posted. You can email me as well, bishoponair@gmail.com.